Hi, I'm Candace Blair, broker owner of Miguel Point Properties. Welcome to Smart Landlording in California. I've been managing and advising California rental owners for over 20 years. And in this series, I'm going to share with you practical strategies and tips to help you manage your property and increase your returns. So let's get into it. We're going to talk about evicting tenants in California, step by step, how it's done. If you manage rental property in California long enough, you may eventually face an eviction. Evictions here are not difficult because they're hard. It's difficult because it's procedural, and one mistake can delay everything. So today I'm going to walk you through the California eviction process step by step. Keep in mind, this is not legal advice. I am not an attorney, but I will give you a clear understanding of what's involved. Step 1, your documentation matters. We have learned through doing evictions in the past how important it is to have a solid lease. All the details in the lease need to be accurate. The names on the lease of the occupants in the property, the proper signatures. And also, if your property in California falls under rent control, there's a specific addendum needed where you check the box that it is either exempt from rent control or if it falls under it. That is a key element to having your lease paperwork in place. The judge is going to look at that. If the tenant hasn't received that notice, then you need to actually provide it and wait 30 days before you can start an eviction. So also having a clear rent ledger with the exact numbers of what your charges are for the rent and what you've received from the tenant is needed. Accurate payment history is very important when you go to court. So make sure that you have a spreadsheet or you have some type of software tracking your rent collection records with the tenant. Written communication is important. So you guys, no handshakes. That was a way of the past. We have to have everything documented, whether you asked for the rent to be paid in an email or if you changed anything in the lease over the term of the lease, it needs to be in writing. The court prefers email communication over text. It's a lot easier to date and timestamp an email than it is a text. So remember, evictions are built on paperwork. The judge does not care about who's right or wrong or emotions. It's all about showing the proof. So if you have messy records, it's going to make for a harder court case. So if your paperwork doesn't tell a clear story, you are behind on the eviction. So this is just easy, quick advice to start off the right way so that if you do end up in an eviction situation, it will be a lot easier for you. Step 2 is serving the proper notice. This is your 3-day notice to pay rent or quit. You can either do this yourself or you can hire an attorney, but make sure that it is done right. So first you have to list the exact rent amount owed, and that needs to size up to your lease contract. No estimates here, and only include fees that are in your lease. So we're not allowed to include late rent in a noticed 3-day notice. And it needs to be properly formatted or it won't hold up in court. So if the names on your lease are spelled a certain way and they're listed a certain way, they need to match exactly on the 3-day notice. Even the delivery address of where the tenant's expected to pay rent needs to be spelled out perfectly on this notice. If it's not done right, I can't stress how important it is. It will put you back like 30 days in court. Also, the proper service of this notice is important. It can be personally served. You knock on the door and you hand it to the tenant. It can be a substitution serving, which is you can post it and mail it. So if you do that, it's going to require some extra days. It's going to be more than 3. It'll be 5. So one tiny error can invalidate the whole notice. And so we did have this happen to us once a long time ago. The notice was served. It didn't have the right delivery address and times of when it can be delivered. And by the time we waited for the judge to get it, the case got thrown out. So very important. Judges do not care about feelings. They care about the procedure. Step 3 is filing the unlawful detainer action. So this is after the notice period ends, you've served your 3-day notice and they haven't paid rent, or you haven't collected a rent or even a portion of rent. The next step is that you would start a formal eviction lawsuit. So this is when you're officially suing for possession of your property. And this gets filed to the Superior Court. And so the tenant would be formally served by the court, and that would take 5 days for them to respond. So depending on how the tenant responds, we all hope that there is no response. And in this case, you would have a default judgment. This will help cut down the cost and help the process move quicker. So if you're doing your part as a landlord, the tenant shouldn't have a reason to respond. But on the opposite side, if they do respond, that's a contested eviction. And that's going to be a little more expensive and it's going to take more time. If it's contested, you really need to have all your records. You would want to have records of all the maintenance requests you've had on the property and how quickly you responded to them, what you did, because you might be defending yourself against a habitability issue. You want to have all the notices that you've posted and really keep your records precise. I can't stress how important it is to have a process for this and to have clear and concise records, because a judge, they can deny the case and then you start over. And when you start over, that's another 30 to 60 more days. And as you know, this is really painful for landlords because it's time when you're not getting rent. Step 4 is the judgment and the sheriff lockout. So the judgment means the court has legally ruled that you are entitled to get your property back. So does this mean you can just go knock on the door and tell the tenant to take a hike? No, you're going to get yourself in trouble. So you cannot at this phase change the locks. Do not shut off the utilities. You cannot remove any of the tenant's belongings yet. It just means your case is moving to the next step. So now the sheriffs can officially remove the tenant. But it's another waiting game because you're waiting for the sheriffs to get the paperwork, to schedule the lockout. At that time, sometimes the last one we did, it took 3 weeks to hear back from the sheriff's department. They're going to contact you. They'll let you know the date that they're going to enter the property, and you'll need to schedule a locksmith at that time because that is the ideal time to change the locks. Before that happens, the sheriff's going to post a notice. It will give the tenant 5 days to leave. And this is actually when the reality sets in for the tenant that they have to move out. And you'll actually see tenants typically move out at this time, and then the lockout happens. But what's very important is what you do after the lockout. If the tenant leaves possessions in the property, make sure do not move them out yet. Follow the California abandoned property procedure for their possessions. Quick story, we had a tenant, it was a lockout. We met the sheriffs. Guess what they left? A little dog. A little dog was in the property. We had to allow a family member to come and get the dog, or we would have been personally responsible for that pet for 2 weeks. So make sure you do follow those rules and do everything by the book to stay out of the courts. So those are the 4 steps to eviction, and even smooth evictions can take months. And don't forget, you've got court fees, loss of rent, stress, and evictions are very procedural, not emotional. So it's more important to screen your tenant to begin with, make sure that they have great credit, good income, and good references. And of course, keep your records precise. And then you shouldn't have to worry about evictions, and we can all stay out of court. So for more smart landlording tips in California, take a look at our YouTube channel, like it and share it with somebody that you think could use some advice in this area as well.